We'll be back, inshallah, next September. Tonight going to be a very special speech with a special guest. Before I introduce our guest, I would just like to invite you all to Sam's first international conference in Free Syria. It's going to be exactly in 6 weeks. If you haven't registered the conference, please do. We are selling out the seat for the conference, and alhamdulillah, we are over 400 registered so far for the conference. So we are getting very close to close the registration. For tonight, I have the honor to have Gina Shkoukani. She is attorney and she is member of the NGE Private Wealth Services Practice Group. Gina focuses her practice on estate planning for high net worth clients, trust administration, and charitable planning. She earned her degree in law, JD, from Wayne State University Law School. Gina has bar admission in Illinois, Michigan, and Washington. She was named as the best lawyer in America recommended in trust and estate since 2023. Also, Illinois Super Lawyers, a Rising Star in estate planning and probate since 2023. Gina also is the chair of Gateway Foundation, Young Professional Board. Please welcome Gina with me. Tonight she's gonna teach us about estate and tax planning for medical professionals. Please, Gina.
Thank you, Nidal. Assalamu alaikum, everybody. As Nidal said, my name is Gina Shkoukani. I'm a member of the estate planning group with Neil Gerber Eisenberg that's based out of Chicago. I'm currently sitting in Seattle, Washington, where my husband and I have been here for almost 3 years. I've been practicing estate planning for just about 10 years, originally in Michigan for a little bit. That's where I grew up, in the Bloomfield Hills area, and then Chicago for 5 years, and now Washington for 3 years. For the most part, a lot of my clients sit mostly in the Midwest, but really throughout the United States. The nice thing with estate planning is that our firm is pretty comfortable dealing with folks anywhere throughout the states. Sometimes there's a little bit of nuances depending on the state, and so we may work with local counsel, but I would say 9 times out of 10, we do planning for folks everywhere. My clients range. I have some medical professionals. I just had a call with some new clients. They're in their early 30s, an anesthesiologist and a cardiologist, and they were interested. They were concerned about some malpractice cases that have been coming out. They were interested in like asset protection planning. They have young kids. They're worried about guardianship. I would say their assets are around 500,000. And then I have another client, also a medical professional, who had a practice that did very well. He recently got a valuation, and the company valued about 80 million. So my clients range from, like I said, 500,000 to 80 million. I've worked with clients as high as 2 billion. So the nice thing with estate planning is that it doesn't matter if you have $2 or $2 billion. I'm able to assist, and you'll be able to learn and learn something new regardless of where you sit in terms of your assets. So when people think about estate planning, they think typically about the basic plans. And that's kind of what I want to start everybody out with today, is the basic documents that you should be thinking about regardless of where your assets sit. So first and foremost, we have a will. For the most part, everybody's very familiar with a will. They think about a will as the document that's used to state how you'd like your assets to be distributed when you pass away. I would say yes, that's true for the most part. I see a will as being the most important thing with respect to designating guardians for your minor children. That's really what the will is utilized for when I'm drafting a document. It's really important for us to know who you would like to take care of your children. God forbid you and your spouse passed away, or you and the child's parent passed away. Who should be responsible for taking care of a child? In addition, the will designates an executor or a personal representative. That name, it's state specific, but the role is the same. So basically, who's responsible for figuring out what is the extent of your assets, who needs to receive what, pay your tax liability, see if there's any credit card debt that needs to be paid, your mortgage, etc. That's the responsibility of the executor. When we're drafting a document, when we're drafting wills, we typically don't like to state how the assets should be distributed in a will. Why is that? Well, a will for the most part is a public document. So in Illinois, for instance, when you pass away, you have 30 days to file a will in probate court. And so it becomes a public document. So if my will's filed, anybody can look it up and say, oh, well, Gina named this person as their executor and they named this person as the guardian, and she gave her assets this and she's worth this much. Most people don't want that. They want a little bit of privacy. So you want to really have as minimal amount of information in a will as possible. So generally what we do is we'll have a will that says everything goes to my revocable trust, and the revocable trust is actually what designates how you would like your assets to be distributed. In addition, if you just have a will and you don't have a trust, you actually still, for the most part, have to go to probate. What is probate? Probate basically is required, for instance, in Illinois, if you have assets over $100,000 that does not have a beneficiary designated on that. So for instance, if you pass away with just a Chase account, a 401k, and a house, and the house is titled with another person, and your Chase Bank has a beneficiary designated, and your 401k has a beneficiary designated, then you're good. You don't have to go to probate. But if you have a luxury car that's just in your name, and the luxury car is worth $150,000, okay, that's a probate asset. Now we're in probate. Probate is a headache. It's money. It's a public. It's public. Everything that you file there is public. For instance, in Cook County in Illinois, sometimes it takes up to 3-4 months to be able to open up probate. So sometimes your assets are kind of held. They can possibly be held up until an executor gets appointed, and then the bank will work with the executor. So ideally, we try to avoid probate at all things possible. So what we then do is then have instead a revocable trust. So I'm sure many of you have heard trust or revocable trust. Well, what does that mean? A revocable trust is basically a document where you get to dictate how your assets are distributed at death. It's revocable. So you can set it up one way today and completely edit it throughout your lifetime. It's not set in stone. The tax ID on it is your social security number. So anything that's titled in the name of your revocable trust is just is shown up on your tax return every year, same as it would be on yours. It's not a separate tax ID. It's not a separate taxpayer. So think about your revocable trust as pretty much you. And so the idea is to create this revocable trust during your lifetime and to fund it during your lifetime. What does funding mean? It means that all of your assets would be titled in the name of your revocable trust to avoid, again, having to deal with probate at death. A revocable trust also does a little bit of tax planning. So depending on where you are on the tax bracket, when you pass away in terms of your net worth, your revocable trust can be set up in a way that can become very tax efficient. And I'll explain a little bit more of that as we go along. It allows for your legacy to continue and for you to, again, distribute things the way that you would like to do. If Sharia compliance is important to you, you can make sure that your revocable trust goes in accordance with that. Next, we have powers of attorney and health directives. I'm sure a lot of you as medical professionals are very familiar with healthcare power of attorney. Obviously, when your patient is disabled and is unable to make decisions for themselves, it's important that we have somebody designated to do that. Same thing with respect to finances, is if somebody is unable to pay their mortgage or take any money out of their bank account, or they're in the middle of selling their house and they need somebody to sign the deed. If you're unable to do that, it's important that you have these documents in place of folks that you trust that are named in these fiduciary positions in order to act for you whenever you need them to. Living will, I'm sure you guys are also very familiar with that. So in terms of basic estate planning documents, this is what it looks like. If you say, oh, Gina, I want to come to you and do estate planning, this would be step one of planning for anybody, regardless of what your income level looks like. So this is how kind of a flow chart of what it would look like. So you have your will, again, designating your executor or personal representative, designating your guardians. Your will say, at my death, all my assets should flow through to my revocable trust. So even if we go through probate, your will is still going to mention the revocable trust. So even if probate has to be open for a little bit, it'll eventually flow through to your revocable trust. Your revocable trust is going to appoint a trustee. The trustee is very similar to the executor. Typically, we name the same individual or individuals, and they are responsible for distributing your assets in accordance to your wishes. So during your lifetime, you are typically the trustee of your own revocable trust. And then if you were to become disabled or you were to pass away, then somebody else would typically step in. Some people appoint just their surviving spouse as a trustee. Some people put spouse and maybe a child to act with them. In terms of creditor protection, it always looks better if the beneficiary of a trust is not acting independently. It's always better to have somebody else with them, again, for creditor protection, liability purposes. And then at death, the revocable trust can distribute however you would like. Generally speaking, my clients have everything go to surviving spouse because that's the best for tax planning purposes, and I'll explain that momentarily. And then when the spouse passes away, trust for your children. So this is kind of like the flow through of picturing how your assets would go. So will to trust and to separate trust. And then again, your powers of attorney and your healthcare powers. So that's the basic planning, but it's important for people to understand how lifetime taxes and estate taxes play within this type of planning. So I would say most people are probably familiar with what I just mentioned. The next part, gifts and death tax overview. Honestly, if I wasn't an estate planning attorney, I probably wouldn't know anything about this. I try to give the scenario of somebody's running a race, a relay race, and they have the baton. Every time the baton goes to the next runner, the IRS likes to hit you with a tax. So during your lifetime, you have what's referred to as gift taxes. GST taxes play a little bit during lifetime, but not so much. I'll explain that in just a minute. And then when the baton goes to the next part, you pass away, now you're hit with estate taxes. And I'm going to explain how they all kind of work together. So, and again, this is complicated, so don't feel bad if you're a little bit confused. Feel free to ask questions at the end, and I'm happy to clarify anything to the best of my ability. So generally speaking, as a US citizen, you are able to gift to anybody $19,000 a year in 2025. So if you're married, you and your spouse can both give $19,000 together to somebody, and that's considered okay. There's no gift taxes, there's no reporting, that's fine. But if you have $50,000 and you want to give it to your kid, technically you are supposed to file a gift tax return. That's a Form 709. So every time you make a gift that's over that $19,000, you're supposed to file a gift tax return. Now, everybody is entitled to, currently in 2025, this amount, $13,990,000. So we're going to just round that up to 14 million just in terms of explaining, because it's just easier to work with that number. So generally speaking, everybody has about $14 million of lifetime exemption. So what does that mean? That means that you can give up to $14 million during your lifetime, and there's no gift taxes that you have to pay. You still have to file a gift tax return because we're trying to let the IRS know, oh, we've utilized some exemption. We've utilized some exemption. So that way they'll say, okay, you have 14 million. Oh, you just gave $1 million. Now we're at 13 million. Oh, you just gave another $1 million. Okay, now we're at 12 million. That's important for the IRS to keep track of that because of it plays a part at death with estate taxes. So let's say you decide to give $50 million during your lifetime. You've done really well for yourself. You have that extra money. It's not going to charity, it's going to individuals. Anything over that 14 million that's not going to your spouse, that's going to somebody else other than your spouse, you are going to pay a 40% tax on each of those gifts. So that's what happens. You get hit with anything over this exemption amount, 40% during lifetime. Okay. Now, if you decide you're a grandparent and you want to give to your grandkids, that's what's referred to as a generation skipping transfer tax. So the IRS came up with this tax because they didn't want people skipping a generation. So anytime you give to a grandkid or somebody that's not related, that's more than 37 and a half years younger than you, there's an additional tax that's tacked on, this GST tax, also 40%. Generally speaking, I wouldn't worry about the GST tax. It kind of plays more into irrevocable trust planning. So let's just put that aside for right now. Estate taxes. So I'm sure a lot of you have heard of this term. So let's say you did some gifting during your lifetime. You had the $14 million exemption. You gave away $1 million, so now you have 13 million at death of exemption. But you passed away and you've done well for yourself. You have $20 million of assets. You would be subject to estate taxes on whatever's over that 14 million. And the federal tax rate is at 40%. So again, that's significant. And in Illinois, you have state estate taxes. So some states have additional taxes of state estate taxes. Anything over 4 million in Illinois is subject to estate taxes. So the rate between federal and Illinois estate taxes roughly is about 50%, which is, again, significant. So again, we have this exemption. So right now in 2025, it's about 14 million. It's subject to be reduced. It's going to sunset on December 31st of this year. This amount is going to go from 14 million to roughly 6 million with inflation. However, for those of you that have been keeping track of the tax bill in Congress right now, the One Big Beautiful Bill Act, there's potential that they may change this to where a $15 million exemption is set in stone. It's unclear what's going to happen right now, but assuming that does not pass and the exemption goes down to 6 million, it's either use it or lose it. So either people are going to do gifting this year in 2025 to utilize this higher exemption, or they're going to lose it and it's going to go down to 6 million, meaning that any assets over 6 million come next year would be subject to this estate tax. Again, in Illinois, the exemption is only 4 million. So anything over 4 million is subject to state estate taxes. I believe the highest percentage is about 14 to 16%, give or take. Anything over 4 million is subject to that. In New York, the exemption is just over 7 million. Some states like Michigan, it's great. There's no state estate taxes. Florida doesn't have income taxes or state estate taxes. So I would say a lot of my clients actually try to retire in Florida just because it's the best place for tax purposes. Same thing with Texas. California doesn't have estate taxes, but you have higher income taxes. So really, when in terms of residency, you really want to look at the benefits of income taxes and estate taxes and kind of weigh the pros and cons to both. What else was I going to say with this? So with respect to the exemption, though, anything that you give to a spouse is considered okay at death. So if your spouse is a U.S. citizen, we are given what's referred to as an unlimited marital deduction, meaning that if I have $50 million, I can give that to my spouse when I die, and there's not going to be any taxes due at the first death. It's the second death that they'll then kick in these estate taxes. So for tax planning purposes, that's why a lot of folks will set up trusts where everything flows through to the surviving spouse. And then at the surviving spouse's death, things will be divided up to the children. What makes it complicated is if you're trying to do things Sharia compliant, then it's not necessarily always the best for tax purposes. So it's weighing the Sharia compliant planning aspect, if that's something that's of important to you, with the tax planning and trying to draft the best way possible that you feel comfortable with. And I've done that for clients of different religiosity levels, and we have documents that are in place for that. So that's just an important thing to understand, that Sharia compliant planning and tax planning is not always hand in hand. So there are some gifting strategies. So for instance, if you have larger assets and you want to make sure that you're able to give away some of these assets during your lifetime, but you don't necessarily want it to affect your exemption, there are some gifting things that you can do that doesn't affect that $14 million exemption. Example, you can give $19,000 worth of assets each year to whoever you'd like. Again, $38,000 for married couples. If your children or grandchildren have 529 plans, you can front load them, so you can give away $95,000 in 1 year and take the full deduction. But you have to make sure you file the proper gift tax return in order to show that you're doing that. Any distributions going directly to an educational institution or a medical facility for anybody doesn't matter who they are, that's totally okay. That's not considered a gift. So if your grandkid goes to the University of Michigan and you want to pay their tuition for them, you can pay the tuition directly to the University of Michigan. You can't give your grandchild the money or give your child the money to pay the tuition. You have to give it directly to the institution, and that's not considered a gift. If somebody that you know needs help with their medical bills, again, you can pay the medical facility directly, and that's totally fine. Lifetime use of exemptions. So a lot of my clients who are high net worth individuals, this is the type of planning that they'll do during the lifetime with separate irrevocable trusts, utilizing this lifetime exemption and kind of chipping away at it during their lifetime with different type of planning tools. This is when you think of like folks that have trusts, or Donald Trump, who's done really well for them himself and has assets in all these different trusts. This is the type of planning that they have, like using different type of irrevocable trusts and gifting different ways to that. And this, I would say, would be like a part 2 level of planning. So your basic estate planning being the documents I discussed earlier, and then a whole level of additional type of planning that you can do as a more sophisticated planning if that's something of interest to you. So I thought it would be nice to look up a plan of somebody's situation if they have an estate plan in place and if they don't have an estate plan in place. Again, being the estate plan, the basic plan, a will, and a revocable trust. So this is a scenario of somebody that's done well for themselves. They do not have an estate plan. It's a doctor, Illinois resident, married, has an 18-year-old and a 20-year-old, total assets of 15 million. Their medical practice, they have a house, they have a 401k, a life insurance policy, a luxury car, investments. And life insurance policy, it's important to know this. So if you have a life insurance policy, let's say a term policy of $3 million, but you have the ability to change the beneficiaries on it, that's considered part of your taxable estate. So you might think, well, I have 10 million, I don't have 13 million. Well, if you have a $3 million life insurance policy, you do have 13 million. So just keep that in mind when you're thinking about your assets that you have. The doctor predeceases the spouse. Probate is required because you have all of these assets and they didn't all have beneficiaries that were designated. Again, it's public. It takes a while to get an appointment. Now in Illinois, your assets go 50% to spouse and 50% to your children. Well, you have $15 million. You have an 18-year-old and a 20-year-old. So you're going to get, these kids are going to split half of that outright. I mean, what if the 18-year-old has a spending problem, or the 20-year-old is going to get married and you're worried about divorce? Like, ideally, you don't want these assets to go outright to young children. Let's say you had charitable plans. You wanted to give a certain amount of money to Sam's or some other 501c3. None of that's going to happen because you didn't have an estate plan to designate how you'd like it to flow. So again, in 2025, our federal exemption is just under 14 million. In Illinois, the state exemption is 4 million with no portability. What does no portability mean? It means that if let's say this spouse only had $2 million, it's not like the extra 2 million can go to the surviving spouse and the surviving spouse can utilize that extra 2 million. Again, it's either use it or lose it. There's no portability of your exemption for Illinois purposes. So your estimated taxes in this situation, federal taxes, 400,000, and state estate taxes, 1.6 million. So you're looking at roughly $2 million of estate taxes just because this person did not have the proper revocable trust with tax planning involved in it. And again, no privacy control or legacy structure. So what happens if this doctor instead paid $5,000 to $10,000 to do an estate plan? Well, same thing. They died with $15 million of assets, but they have a revocable trust. All of their assets were titled appropriately. And we have three separate trusts that were created for tax planning purposes. Everything went to the surviving spouse at this doctor's death. We have creditor protection for the children. We have all the tax planning language in place. The legacy is preserved. If they wanted to do, again, an outright gift to Sam's, they can go ahead and do that. They've included that in their revocable trust. What happened? 0 estate taxes paid at this first death. So again, in the first situation, paid $2 million. in this situation, because they have a revocable trust in place and everything's titled appropriately, 0 estate taxes at the first death. I'm just going to show you a sample of what our trust structure kind of looks like in this situation. So let's say doctor's name is Muhammad Ali. Again, this looks a little bit very tax heavy, but this is kind of just the structure that we use. And it basically checks all of the IRS boxes. And but in reality, you're still able to provide for your spouse and have the type of language that you would like, but there just needs to be certain IRS language legalese that needs to be incorporated. But basically, all of your personal effects will go to your spouse, like your car, your clothes, your watches, things of that sort. We have one bucket of a trust that's completely protected from Illinois estate taxes. Another bucket that's the remainder amount of this federal exemption. So basically, at death, no estate taxes are paid on Muhammad's death if his spouse survived him. At the spouse's death, this amount would be subject to the Illinois estate tax, and this amount would be completely subject to the federal estate taxes. So it's basically prolonging the taxes due with the goal of spending this down during spouse's lifetime to minimize the type of taxes that you would have to pay at the second spouse's death. So that's a little bit of how we utilize trusts in order to prolong having to pay taxes. A revocable trust, and I know a lot of doctors are worried about asset protection and being sued in malpractice. A revocable trust during lifetime doesn't have any creditor protection. So it's important to know that. It's not until the one spouse dies and you have an irrevocable trust, that is when you have a level of creditor protection. We do have type of planning tools and trusts that we can use for quote unquote creditor protection. There's rules. Obviously, you can't be currently being sued or have any potential liability. But usually when you're doing that type of planning or with trust, you need to kind of give away assets that you don't necessarily need or rely on. Because when you're gifting it to an irrevocable trust, the idea is that you're giving it away and you don't have control over those assets. So, I mean, there's levers and maneuvers and language that we can include in the trust that still give you a little bit of flexibility. But yeah, so it's just important to know that the revocable trust does not give you asset protection. It's an irrevocable trust that would give you the asset protection trust. And that's it for Estate Planning 101. I'm happy to answer any questions that you guys might have.
Thank you so much, Gina. Please, if anyone has like question, you could write in the chat box, or you could unmute yourself if you have a question.
I got one on my own.
Yes, please.
So I understood. So I have a trust and a will, but I understood from my attorney is that the revocable trust actually can protect your assets, especially if a lawsuit would happen and stuff. So what's the reason it cannot be? It's not protective.
So your revocable trust, basically, because you have complete control over it, and it's revocable, meaning you can get rid of it at any point. There's no protection. So the IRS only gives you that level of protection when you yourself do not have control over an asset. So if you give away your assets to an irrevocable trust that you are no longer the beneficiary of, and you aren't the trustee of, you don't have control over how things, what happens to those assets, that is what gives you the creditor protection. But if you just have a revocable trust, you can do whatever you would like with those assets. You have free range of control of it. So there's no protection until you die. Then that trust transfers from a revocable trust to an irrevocable trust, and that's when the creditor protection would come into play.
So let me ask you this very quick. So you have a revocable trust, and you put your houses in the trust. Let's say you have I don't know, an example, a rental property. You have it in an LLC, and the trust owns the LLC, right? And you know, somehow you get sued, and then somebody decided to go after your assets. You're saying that your homestead and your rentals and everything in that trust is exposed?
So your LLC gives it a level of protection. But what I'm saying is that in terms of like malpractice and things like that, the revocable trust doesn't give you that protection against like malpractice suits. I recommend that if you're in a state that allows tenants by the entirety to hold your home, tenants by the entirety is actually a very strong way to hold a property for your homestead. And so, for instance, if you get sued and your spouse's name is, you guys are holding that property by tenants by the entirety, somebody would only be able to put a lien, but they can't foreclose on the lien. So the home cannot be taken away. So tenants by the entirety actually is a strong way of holding a home.
I have a question. So you're saying that at the time of death of the person, if the spouse gets the money, it's a better, plan. But that's contradict the Sharia, isn't it? Is the Sharia?
Yeah, that's what I said. So I said, if you give everything to your surviving spouse, that's the best for tax planning. But I said it's not the best for, it goes counterintuitive to Sharia compliance. So I have some clients who they'll basically give everything to surviving spouse at the first, assuming that you're a taxable estate, that you're worried about paying estate taxes. They'll give everything to their surviving spouse at the first death, and then they'll put in Sharia compliance at the second death. I have other clients that have it fully Sharia compliant, and they acknowledge that they will pay estate taxes at the first death. So it just depends on what's important to you.
Thank
Hey,
you.
Gina.
Yeah, we have a couple of questions. Is shared bank account taxable? Like for couple, they have like shared saving account. Is that account taxable if someone die?
Yeah, so if somebody passes away and they are close to the exemption amount, so you're looking at, so for instance, let's say you're again in Illinois and you're over the 4 million, so you're going to be taxed for Illinois estate taxes, and then you're close to the federal exemption. You have to fill out an estate tax return. So that's a Form 706. In the Form 706, you'll include all bank accounts, and you'll include how the bank accounts are titled. So if it's a joint account, generally speaking, the IRS will either say a joint account, they'll attribute 50-50, assuming that you are in, it also depends on what type of state you're in, if you're in a community property state or not community property state. But let's just say you're in Illinois, it's not community property. The general rule is it's split 50-50. Sometimes we have people with accounts, it'll be dad has an account and daughter's name's on it just in case something happens to dad, they want the daughter's name on it, but the daughter didn't contribute anything to that account. That account would be considered the full value would be on the dad's federal estate tax return. So it just kind of depends. I hope that answers your question.
Okay, thank you. We have a question. What would be the best way to go about making sure the assets are distributed according to Sharia? Like, what's the best way?
Yeah, so it depends on how sophisticated your assets are and if you're taxable or not taxable. Some people feel comfortable if you're not taxable, you're not worried about estate taxes or anything like that. People are comfortable with leaving everything to one person and telling that person, hey, make sure you divide everything in accordance with Sharia compliance, and they trust that person to do the division, that's fine. But if the IRS is going to be involved because you're at a taxable level, we've drafted trusts where we basically state in the trust that everything's divided in accordance with Sharia compliance. We appoint an individual that will work with a sheikh to basically oversee the Sharia compliance at the date of death, because what's complicated is I can't say it needs to be divided X, Y, and Z because somebody could pass away before you, and then the division will be completely different at death. So it's not like we can state how the division would happen at first person's death because we don't know who's going to be living. So we have tools in place to draft the documents that allow that flexibility that the IRS will respect. Just knowing though that you will potentially trigger estate taxes at the first to die if everything is not going to the surviving spouse.
Okay. And I think that answer another question. Do you help in Sharia compliance trust? Like if one
I
of the
do.
member
Yeah,
reach out to you?
yes. Yep. Mhm.
Okay,
There's a
great.
few people in the States that I know that do Sharia compliant planning. It's definitely not something that a lot of people have familiarity with, but I've had the opportunity to do quite a bit now.
Can you share your information or phone number or email?
Yeah, so let me go back to the first page.
Yeah. In the meantime, oh, go ahead.
Sorry, I have a question. شكرا كتير سلم ايديكم. ممكن تشرحينا شوي على الجفت
Sorry, I
tax?
don't speak Arabic.
Oh, I'm sorry. Can you please
It's okay.
elaborate a little bit on the gift tax? Like if we do not report the 19,000 for the IRS,
Mhm.
so what's the benefit of that then? Because they're not calculating or tracking the 19,000 every year. We gift it to the kids. So how I get benefit from that then?
Yeah, so it really comes down to if you don't report certain things and the IRS finds out about something later down the road, they can say you didn't report it from day one. We are now we're now going to apply a penalty and interest from all this time that you didn't report this. So, like for instance, if people go ahead.
My understanding that we're not required to report it, the 19,000. Is that true? Probably I
Right, you don't have to
misunderstood that.
report correct. You don't have to report anything above that. You're supposed anything. So if you're married, anything above
Yeah.
38,000, you're supposed to report.
Is it better practice to report the 19,000 as a gift then?
If you're just doing I have some clients that just like to be so for instance, if they do standard gifting, like they transfer cash to their kids every year, they like to reflect that. They'll report that in a gift tax return. I always tell I don't think it's necessarily necessary to do a gift tax return if you're just doing 19,000. I think if you are doing taxable gifts, so for instance, you've created this, like you have an insurance trust or you have an irrevocable trust that you're gifting to, and you're also doing these separate $19,000 gifts, I think then you can report that. But I wouldn't necessarily file a gift tax return just to report non-taxable gifts, if that answers your question.
A quick question on that. I'm sorry. If I'm married and I'm sending gift for my father who's married to my mother, is it 19 from me, 19 from my wife, and then that's also one for my dad and one for my mom? So the total will be close to 80,000 or no, 70,000 or no?
38 to your dad and 38,000 to your mom.
So it does count that way?
Yep.
Thank you.
Hi, thanks for an excellent talk. I just wanted to clarify one thing and I have a question about another one. It was regarding the gift tax. I understand that you do have to disclose or file when you give above that amount, the 19,000.
Yep.
But as long as you remain underneath that, almost 14 million in a lifetime, there's no limit annually how much you can give to anyone, but specifically from like a parent to a child, correct?
Yeah, I mean, technically speaking, you're not supposed, I mean, so you can't give during your lifetime more than the federal exemption. The issue is that you don't know what your exemption is going to, you don't know if the exemption is going to decrease by the time you die. So at one point, I don't recall in which year, the exemption was only $1 million. So anything over $1 million was subject to estate taxes. So that's why we recommend to report these gifts, because we don't know where the exemption is going to be down the road.
Understood. But like hypothetically speaking, you buy your child, I don't know, like a $50,000 car. You can do that, but you just have to report that you spent more than 19,000 that specific year.
Correct. And it does not
incur
a gift tax return. It does. Yeah, you don't pay a tax. It's just showing the IRS, hey, I'm using some of my exemption, but you wouldn't incur a tax until you've exceeded that 14 million.
Excellent. Thank you. And then just sorry, I don't want to take up too much time, but the other question I had was about asset protection. You had mentioned about how you can title your home. Some states don't allow
Tenants
that.
by the entirety. Yeah, some
Yeah.
states don't allow that.
So if those states have homestead laws, though, is that a adequate asset protection from legal?
I mean, it's helpful for sure. It's helpful.
Okay.
Tenants by the title are stronger. Yeah, each state, it's hard to just give you a blanket like yes or no. It's really state specific.
Okay, thank you.
Do you work in California?
I have worked in California before. I have clients in California.
Thanks.
So if we have a few questions about this, like you could help clients from any state, not just like the 3 states that you have bar admission.
Yeah, exactly. So we have bar admissions are really important in terms of like if you're going to court, if you're a litigator and you need to go to court at those states, they require you to be barred in those specific states. With estate planning, as long as we draft your documents and they're executed in accordance with that state specific law, it's fine. For the most part, like I said, estate planning doesn't really change that much each state, and we're always able to look up whatever nuances there are. In only a few instances have I had to work with local counsel on maybe a very specific niche area, but generally speaking, yes, like our clients are all throughout the US.
Okay. Now for like couple, do we have like trust for each one?
Yeah, so it just depends on what you're looking to do. So some people will do joint trusts. We always typically recommend people do separate trusts, mostly because it's just easier to have everything separate. God forbid you have a divorce, with the divorce rate being so high these days, like it just makes sense to have separate documents and separate trusts. Also for creditor protections at the first to die, it's nice to just have these things separated. But yeah, some people do have joint trusts. It's really depends on the person.
Okay. There is a question about gift tax. Does the amount reduce my tax bracket or tax liability, or only non-taxable to the person receiving the tax? I don't think it's decrease your bracket, right? If you are gifting someone, it should not.
What do you mean by like the income tax bracket?
Yes.
No. So if I'm giving,
it's not like donation. It's not like donation to charity. Yes.
Yeah, you don't get a deduction if that's what the question is. No.
There is a question. Why are these type of state tax if everyone with those type of asset have a trust? Also, who set up revocable trust and asset planning? Lawyer or CP or CFP or someone else?
CPA.
Yeah.
Yeah. Anything with trust, in terms of creating the trust, it would be a lawyer that would set it up, but you would work with the CPA to make sure everything's taxed effectively. So basically, like I typically work with a person's accountant, their wealth advisor. Like you kind of work as a team. If somebody is getting an asset valued, I'll work with the valuation expert. So yeah, but in terms of drafting the trust document itself, it's the attorney.
Okay. Hopefully, any other question? Hopefully,
Yes,
I didn't miss any question.
Yeah, I have a question. Thank you so much for your time. I have a question about the retirement plan and your brokerage account and your saving checking account. So for your retirement account, if you just designate your wife as the beneficiary, and after I pass away, and would my wife pay any taxes on that?
So it's subject to estate taxes if but she wouldn't have to pay, like just by receiving it itself, she doesn't have to pay a tax, like it doesn't incur like a penalty or a tax. But so though there's income taxes that she'll have to pay, but it's part of your it's part of looking at all of your assets. It's gonna trigger that 14 million. So again, like it's part of, you can't give more than 14 million. If that's part of your assets, it will be part of the liability of what you owe for estate taxes.
I see. So if my net worth is less than 14 million and I pass away and she got 3 million worth of tax, stocks, or mutual
Yep,
funds,
she's not.
that's hers, and she you
Yep.
know, she just pay taxes like income tax when she sell that tax.
Correct. She's not going to pay any estate taxes.
How about if you have post-tax brokerage accounts, like just the stocks that I bought, not part of my retirement plan?
Yeah, same thing. So these taxes, the estate taxes, are only if you're over that threshold. But if you're under that threshold, you're not going to pay any estate taxes. And any assets that you hold in your revocable trust or in your individual name, all of those assets receive what's referred to as a step up in basis at death. So any of your assets will transfer to your spouse or your children, whoever you name. They'll get a step up in basis. So if they were to go ahead and sell that stock or house right after, they wouldn't pay any capital gains. It would be at fair market value. So whereas if you were to sell it, if you bought something with a very low basis and it appreciated significantly and you were to sell it, you're going to pay that high income tax.
Would you mind if you repeat that? I don't think I got this point.
Yeah. So let's say that you you bought Apple stock and you bought the Apple stocks when it was worth $2 and now it's worth $2,000. When you die, instead of your spouse receiving that stock with the $2 basis, and if she were to sell it, they would have to pay the capital gains on the appreciation. They receive that stock at fair market value of the date of death. So there's no capital gains tax that they would have to pay if they were to sell it after you die.
That's if you like, how would you get advantage of that? By having a trust?
No, anytime in general, if you have an asset, even if you hold it in your individual name, once you die, all of those assets get a step up in basis.
Okay, perfect. That makes sense. And the same thing for saving a checking account. If you write pay upon death to my wife, she, as long as it's below the threshold, she just get the cash money. She doesn't pay any taxes on it.
Correct.
So really the most important things about state tax, if your net worth is over 14 million, but that's subject to change.
Subject to change. And also if you're in a state that has state estate taxes, like I said, in Illinois, you have that 14 million. In Washington state, it's just over 2 million. And also, if you just want to make sure that your assets are outside of having to deal with probate and making sure that things are held in trusts after you die, just for, like I said, if you're worried about like asset protection or your kids, like you don't trust them to receive such a large amount at 18, things like that.
Perfect.
Because
that's super helpful. Get your time.
Because the process may take several months, right? In that probation court to distribute the money or the asset.
Usually probate between opening and closing is it ranges anywhere from 1 year to 5 years, depending on what the what the situation looks like.
I think this by itself it's a reason to have a trust.
And
like
I have
5 years
friends
is a long time.
I have friends who passed away with minor children and they didn't have any documents in place. So their kids will be dealing with probate until they turn 18. So basically the court oversees the administration of the children with a guardianship until the kids are 18.
Wow. I have one more question.
Yep.
If someone has special need child, any like tips to keep in mind to help with the tax?
Yes. Yeah. So a lot of our revocable trust, how we draft it, we have special need trust language in there. So a lot of times the government will give kids, they'll pay for these children. So you don't want them to have a certain amount of assets. That way, then the government will no longer pay for them. So we have our documents automatically set up where it has the language that the government will still be able to provide for them, but they have that level of protection in the special needs trust. I wouldn't say that I specialize in special needs planning by any means, but we have at least that language that still allows them to receive money from the government.
Okay, thank you.
I have a
Regarding,
question. Go ahead.
can I ask this regarding the special need? Just a quick question
Yep.
related to it. So if you leave certain property in the name of that child,
Mhm.
and the child received some government support, does that mean
Yep.
when the child passed away, the government will take everything in the name of the child? Is that correct?
I think if it's not in trust, yes.
Even if it is in trust, someone was saying if once they receive government support, if the property, they're the beneficiary. If it's not in their name,
Yeah.
but they're the beneficiary.
I would have to again, I don't deal with this a lot, so I'd have to double check it, but I'm pretty sure that as long as we have certain language within the trust and they don't, yes, they're a beneficiary, but they don't have any control. They're not a trustee. And when they die, those assets flow through to somebody else. I don't think the government is able to take the money in that trust.
Okay,
But I
very
can,
good. Thank you.
if you email me, I'm happy to look into that and get back to you.
Sure. Thank you.
Mm-hmm.
I have a question. You mentioned about like irrevocable trust is protected for assets, revocable is not. Now, I want to hear your comment about, one time I heard about like, the problem with irrevocable is that you kind of lose control, and not everybody is completely comfortable with that because you cannot change it anymore. But they said if you want to do revocable, but buy umbrella insurance, that would be protective for assets. What's your comment on that?
So that's umbrella insurance and all that. That's definitely works. We've done what's referred to as spousal lifetime access trust. So, for instance, one spouse will create a trust for another spouse. So let's say your wife creates a spouse for the benefit of you and your children, and transfers stock or cash into that trust, and you are the beneficiary of that trust. But you're not a trustee of that trust. You're a co-trustee. Somebody else is kind of technically controlling it, but you kind of have a hand in it. You can remove the trustee and replace the trustee. You now have a trust for your benefit, and that's outside of your estate. So creditors couldn't necessarily attach to that. However, like if somebody were to get a divorce, then it can get complicated. So it's just weighing the estate tax, liability, divorce potential, all when doing this type of planning. You have to like weigh the pros and cons.
Okay, thank you.
I have one question when it comes to the gifting, if it's okay.
Yep.
Yeah, if you are, let's say, sending your father, let's say 100,000, but this is not a gift, it's like a loan that next year or the year after he'll pay you back. I mean, what's in the law distinguish between this is a gift and this is a loan?
So the IRS looks at these things often. So we have a lot of clients that give children loans all the time. They say it's a loan and they like have a paper that says it's a loan, but in reality, they know that their kids aren't going to pay it back and they're not going to ask for it back. So basically we always recommend that if somebody has this, that they paper it. And a lot of times the IRS requires that if you are doing a loan like this, that individuals have to pay a certain type of interest on it of whatever the going rate is. So it's a 75-20 rate. So you'd have to look it up to see what that amount is. And so the IRS doesn't allow you to just do necessarily a interest-free loan to somebody without it being considered a gift. Whatever, if you choose not to take the interest, you're supposed to file gift taxes for whatever that interest amount would be, and that would be considered the gift.
Thank you.
Thank you. I will ask you the last question. You have a question? Go ahead.
Can I give my parents certain amount of money as a gift, but it is as like to cover their expense, like house rent or house mortgage? But I will say that this is for their gift.
So that's considered a gift. So if it's more than 19,000, or 38,000 if you're married, technically that's considered a gift and you're supposed to file.
How about if I pay for my kids, it has to go directly to their bank account as a gift or as expenses, like paying for, like my son, he
So if
has
they're
house, I will pay for the rent.
Yeah, if they're minor children, then no, it's okay. But if it's like, and it's just their normal, like, you know, their living expenses, that's fine. But if they're adult children and you're paying for their mortgage and things like that, and it's exceeding the 38,000, if you're married, yes, that's considered a gift.
Okay, thank you.
Yeah, so ask you the last question. Is having beneficiary for retirement account eliminate the probate process?
It does. So anytime you have a beneficiary designated and or your asset is titled in the name of a revocable trust, that's how you avoid probate.
Okay. Thank you so much. If anyone has any question or like to work with Gina, this is her information, her phone number, her email, and now everything, you could do it like Zoom and virtually. You don't need to be in her office. So feel free to contact her. Gina, thank you so much for this talk. It's very informative.
No problem.
And we appreciate your presentation. Thank you.
No problem. Take care, guys. Assalamu alaikum.
Wa alaikum salam. Thank you everyone for joining us tonight.
Thank you.
Thank you.
Thank
Great job, Gene.